Welcome back to this final segment of this law session on English legal system relating to miscarriage of justice in the context of the criminal justice process. Now, immediately before the break, of course, I said to you that on return, we would look at the conflict between crime control and due process in the miscarriage of justice cases. Now, we are going to review some of these cases, and what I want you to take on board as we're viewing them is what exactly, as it relates to the theory, which makes sense in the context of the cases. So when you're looking at it, think about the crime control, think about the due process. What would you suggest would have been the best in the circumstances? Should the persons, for example, had been arrested and it was right in the circumstances? Should the police have fabricated evidence? Should they have done what they did because of the climate? Or is it that you're looking at it from more of a due process? Let's start with some of these cases. The first one is, of course, the Guildford Four. Now, in the case of the Guildford Four, there were 4 defendants who had been convicted in 1976. They were convicted of murder by causing an explosion in a pub, and the pub, of course, was located in Guildford. Now, their appeal against conviction was turned down. Now, in 1989, their case was referred to the Court of Appeal. The Home Secretary, the Director of Public Prosecutions, stated that he no longer sought to support the convictions and the court quashed them. Now, the primary ground was that the tests on police documents undermined the evidence of the police officers that the crucial interviews were recorded contemporaneously, since the handwritten notes had evidently been written after the typed records of the interviews. Now, what the idea was that if you're a police officer, then you are supposed to take these notes contemporaneously. And before we had, a lot of tape recordings and the like, you had to, of course, do a tape recording and then you did it contemporaneously. Here, though, they had typed up the records and then did them contemporaneously, which of course can't happen. Now, in another case of the Maguire 7, in that case, the defendants, who were mostly members of the Maguire family, had been convicted again in 1976 of an offense of possessing explosive substances that were linked by the prosecution, or the prosecution anyway said it was linked to bombings in London and in Guildford. Now, their application for leave to appeal was refused in 1977. After the convictions of the Guildford Four had been quashed, the Home Secretary asked the main inquiry to consider this case, but then referred the case to the Court of Appeal. Now, the Court of Appeal quashed the convictions in 1992, and there were 2 main grounds. First, the prosecution had failed to reveal to the defense certain scientific evidence which amounted to a material irregularity. And second, the scientific evidence left open the possibility that traces of nitroglycerine found on the defendants and in their house actually came from an innocent source. And apparently the innocent source was that it could have been found on playing cards or something like that, which then of course rendered the verdicts unsafe and unsatisfactory. The defendants had spent some 13 years in prison, and one of them had actually died in prison. Question again, look at the climate at the time. You have to look at, was the approach in the mid-70s more of a crime control approach? Was it that it's a situation where you have to consider how for example, the state looked at the whole situation? I'm always intrigued, actually, and I was told, I really don't know how true this is, but I was told when I first realized it sort of hit me that there was actually no garbage bins on the London Underground. I was told that it was precisely because of this whole idea of bombs being left there. And so the climate at the time was that in the 70s and so on, they wouldn't have the bins on the London Underground. Now, I don't know how true that is, but that is what I've been told. It does seem to make sense because even now you don't really see them. I was quite surprised maybe about 3 weeks ago when I saw them having a sort of clear plastic bag stuck to one side. But if you travel the London Underground, you will notice there are no bins on it. But there it is. The next case, of course, is the Birmingham 6. They were convicted in 1975 of murder by causing explosions in a pub as well. So there was this wave of bombing pubs. Now this pub was in Birmingham, and the appeal against conviction was dismissed in 1987. The Home Secretary used his power to refer the case back to the Court of Appeal on the grounds that fresh scientific evidence had become available to know that the defendants had been beaten after their arrest. The appeal, of course, was dismissed in 1990. The Home Secretary referred the case again back to the Court of Appeal, further to fresh evidence, and in 1991, spectacularly, Court of Appeal quashed their convictions. Now, the defendants had maintained from the outset that they were beaten and that the so-called confessions were false. Among the reasons given by the Court of Appeal were the facts that all the notes of an alleged interview could not have been written contemporaneously, and this was established by electrostatic analysis. Secondly, the Forensic Science Service's findings that the traces of nitroglycerin could have come from an innocent contamination or even smoking had not been disclosed to the defense or to the trial court. And the Crown Prosecution Service decided that there was sufficient evidence to prosecute 3 of the police officers involved in the case for perjury and conspiracy to pervert the course of justice, but the judge stayed the prosecution on the grounds of publicity surrounding the Birmingham 6 case. Now, the publicity, of course, he said, would make a fair trial practically impossible. Now, there was the M62 bombing, and again, 1970s case. Here we had Judith Ward. She was convicted in 1974 of murder and causing an explosion. She did not appeal. In 1991, the Home Secretary referred her case to the Court of Appeal, and in 1992, her convictions were quashed. The first ground was that the Forensic Science Services had failed to disclose the results of tests that were favorable to the defendant, and that there were other failures of disclosure by the DPP, the police, and the prosecuting counsel. Now, the second ground was the defendant's mental condition, a form of personality disorder which rendered her confession unreliable. Medical evidence available at the time of the trial to the prosecution had not been disclosed. Now, there was fresh further evidence from that showing that certainly, or showed that the conviction was unsafe. Now, since the prosecution case rested chiefly on statements by the defendant, the conviction was regarded as unsafe and unsatisfactory. Ward had been in prison for 18 years. Now, in the case of the Tottenham 3, the defendants were convicted in 1986 of the murder of a police officer during disturbances at Broadwater Farm housing estate in Tottenham. This is, of course, a housing estate in North London. Now, their appeal was unsuccessful. In 1991, the Home Secretary referred their cases back to the Court of Appeal. The convictions were quashed. The principal ground was that the electrostatic tests that were done on the notes of the interview showed that some parts of the alleged records had been written at different times. If it's contemporaneous, it shouldn't be written at different times. If it was, it should have been time dated as such. Apparently it wasn't. Although much is made of the fact that investigations of all the earlier cases took place before the controls which were introduced by the Police and Criminal Evidence Act were in place, in this particular case, pace was being tested in the police divisions where the defendants were questioned. So it's interesting to see that you have a 1986 case which would have been post-pace. Now remember, what is it that where the models show? Is it to raise the errors? Because if it is that there were structures in place for there not to be errors, how come it ended up the way it did? The Cardiff 3 were convicted in 1990 of the murder of a Cardiff prostitute. Their convictions were quashed by the Court of Appeal on the ground that the tenor length of the police interviews was such that they should be excluded from evidence. Now, the Lord Chief Justice held that the techniques of interrogation which was used by the police amounted to oppression under Section 76 of PACE. The court said that when you looked at it, there was bullying, they were shouting at the suspect by the police, and as such, it really meant that the convictions simply could not stand. Now, if you look at the Royal Commission on Criminal Justice, I flagged it up earlier, but when we consider the whole line of those cases and we come forward to looking at this whole point of the Royal Commission on Criminal Justice, I have returned to it for a reason, because I want you to see what the criticism, particularly from Michael Zander QC, who's a noted academic, and what he's had to say about it. Well, the Royal Commission on Criminal Justice, the Royal Commission on Criminal Justice was set up by the Home Secretary on the day that the Birmingham Six were released. It was chaired by Lord Runciman, and its report was published in 1993. Now, the Commission's term of reference were to examine the effectiveness of the criminal justice system in relation to 1, its effectiveness in securing the conviction of the guilty, 2, its effectiveness in acquitting the innocent, and 3, its effectiveness in the efficient use of resources. Now, the Royal Commission was criticized for failing to identify any clear priorities among these 3 potentially competing objectives. Now, the report had some 352 recommendations, but when it came down to it, it seemed to not give any priority among the objectives that were within its remit and clearly were competing objectives. Now, some gave priority to protecting the innocent against wrongful convictions, but other of the recommendations gave priority to the conviction of the guilty or to the cost efficiency of the system. What I would urge you to do is to look at some of these recommendations and see precisely what had been set out. Now, when it gave its recommendations, the Commission was attempting to strike a balance between the 3 competing objectives. Now, it has been criticized for failing to provide any moral or ethical principle. And this is an important concept, because it has been criticized, particularly by Zander, that it doesn't provide any moral or ethical principle to guide its decision making when it was setting this balance. Now, before we go on to look what Zander says, I want to flag up the Stephen Lawrence case and the Macpherson report, because here we see questions about the avoidance of miscarriage of justice being raised again following the racist murder of Stephen Lawrence, who was stabbed to death while waiting at a bus stop in South London. Now, the English legal system has failed, or initially failed, to bring his killers to justice, and in 1997 a judicial inquiry was set up by the Home Secretary under a former High Court judge, Sir William Macpherson. Now, in the Macpherson report, which was published in 1999, he accused the Metropolitan Police of institutional racism, and he made a series of recommendations which sought to balance the whole crime control and due process model. And the most radical recommendation in this respect is to end the Asian principle of double jeopardy, because what had happened was, based on the police actions, it meant that evidence was destroyed or deteriorated, and then because of the double jeopardy rule, suspects couldn't have been brought to trial. You had, to an extent, some trial by media situations, which I remember the Daily Mail publishing the suspect's picture on their front page and saying, "Guilty, sue us if you dare," kind of thing. And it really was a very kind of climate of hate and concern. But in the end, we see that the legislation was changed, and eventually it provided for the double jeopardy rule, because subsequently the change in the law meant that the prosecutions could be brought and they were eventually convicted. I do want you to bear in mind, I flagged this up in the first segment, when you look at the models and when you look at it from the standpoint of the victim versus the standpoint of the defendant. So if you're looking at a due process model, for example, and you say, right, these persons, the whole double jeopardy rule was not there when this when they committed the crime, what are your thoughts? Because it may be an unpopular discussion, but the fact of the matter is, from an academic standpoint, you really should take it on. Now, facing the ethical question, in his Hamlin lectures, which were published in the State of Justice in 2000, Michael Zander said that previously the Court of Appeal had the power to quash a verdict if it was unsafe or unsatisfactory. He said the revised formula in the 1995 Criminal Appeal Act Section 2 now provides for the verdict to be quashed if it is found to be merely unsafe. His opinion was that the change from the old formula of unsafe and unsatisfactory to the new formula of unsafe raised a fundamental issue. And he said when you look at the majority of the Royal Commission and how they considered what had to be done, he said they took the line that if there is solid evidence of guilt, the conviction is safe regardless of whether the prosecution has behaved badly. So far, the judges have disagreed on this important issue of principle. There have been cases where it has said it could not intervene and others where it said it could. When he looked at it, he says, this is Michael Zander, he says, my own strong belief is that the Court of Appeal must be free to express its repugnance for especially objectionable conduct of the police or other prosecution agencies. It is not sufficient to say that prosecution misconduct can be handled separately by disciplinary action against those concerned, even if that occurred, which too often is the case. And Zander believes that the integrity of the criminal justice system is a higher objective than the conviction of any individual. The point being, when you look at the Royal Commission, they were saying, well, yes, it may be that there was some unsavory action by the state actors, but that should not render the conviction unsafe. Zander's position is that the integrity of the system is what is important. And if it is that the integrity is impeached, then simply the conviction cannot stand. I will, of course, leave you on that point for you to ponder the basis for the criminal justice system and which is the better model, if at all, crime control or due process, or do you consider that they live harmoniously and you need to take from the both? And certainly I would ask you to consider the O.J. Simpson case on this point. Look at it and see what you think in the context of the theories. That ends this law session.